Welcome to this explainer on strict products liability. Today, we're jumping right into how the legal system balances the constant push for corporate innovation with the absolute necessity of keeping consumers safe. I mean, think about it. Whenever you buy something, whether it's a bottle of soda, a piece of heavy machinery, or even a high chair for a child, you're trusting that it's not going to hurt you. But when things actually do go wrong, who's left holding the bag? Well, let's find out. So, here is our roadmap for today. We're going to cover from fault to defect, the exploding bottle, judging the design, the Risk Utility Act, failing to warn, and finally, protecting the consumer. All right, let's kick things off with Section 1, from fault to defect. We have to start with a massive, literal paradigm shift in the law. Back in the day, in a simpler, mostly agricultural society, if you got hurt by a product, you had to prove negligence. Basically, you had to prove the manufacturer's specific conduct was unreasonable or at fault. But as the world industrialized and things got incredibly complex, that became almost impossible to do. How do you prove someone made a mistake in a massive factory hundreds of miles away? You can't. So the law shifted to strict liability. The focus completely moved away from what the manufacturer was thinking or doing and zeroed in entirely on the dangerous condition of the product itself. Legal scholar Dean Keaton really hit the nail on the head here. Notice that last part. You no longer have to impugn or attack the maker. You only have to impugn the product. It's a game changer. It means that even if a manufacturer was super careful, took every reasonable precaution, and acted perfectly safely, if the product they put out there is ultimately unsafe and hurts someone, they can still be held strictly liable. So, legally speaking, there are really only three ways a product can be considered defective. It's either a flaw in how it was manufactured, a danger in how it was designed, or a failure to warn the user about how to operate it safely. Let's break these down one by one. Moving right along to Section 2, the exploding bottle. Let's look at a pretty startling real-world accident to understand that first category, the manufacturing defect. The facts here are simple but honestly terrifying. Helen Lee was working as a waitress at a steakhouse. She was just transferring a big 26-ounce glass bottle of Coca-Cola into a waist-high cooler. She didn't drop it, she didn't bang it against anything, but as she lowered it, it spontaneously exploded with a loud bang. The cap and neck were left in her hand, and the glass fragments severely injured her wrist. Now here's the huge problem for the lawsuit. Somebody swept up all that shattered glass and threw it away, totally destroying the specific physical evidence of the defect. So the evidence is literally in the trash. What now? Well, the court leaned on a legal doctrine called res ipsa loquitur, which is Latin for the thing speaks for itself. This is what allows a jury to rely on circumstantial evidence. The court basically said, look, glass bottles don't just spontaneously explode in someone's hand, unless there was a manufacturing defect when it left the plant, assuming, of course, the waitress didn't mishandle it, which we know she didn't. Now, it's worth noting the trial court actually messed this up at first. They instructed the jury using an old negligence standard, asking if the manufacturer used reasonable care. The Supreme Court had to step in and reverse that, pointing out that injecting reasonable care totally ruins the concept of strict liability. Again, if the dangerously defective bottle exists and causes harm, the bottler's level of care just doesn't matter. They're strictly liable. End of story. All right, Section 3, judging the design. With our second pillar, we aren't talking about a random mistake on the assembly line anymore. We're looking at a product that was built exactly according to its blueprints. And that creates a giant puzzle for the courts. With a manufacturing defect, you can just compare the broken one to a good one, right? But if the design itself is the problem, every single unit on the market is exactly the same. So how on earth does a jury decide if an entire blueprint is legally defective? To figure that out, we look at the landmark case of Barker v. Lowell Engineering. Ray Barker was driving this massive 17,000-pound high-lift loader on some really steep sloped terrain at a construction site. The machine started vibrating and tipping. Barker leaped out to save himself, but he ended up getting struck by falling lumber. In court, Barker argued the loader's design was inherently defective because it didn't have outriggers for stability, a roll bar, or seatbelts to protect the driver if it tipped over. Out of that case, the court established the first of two tests for a design defect, the Consumer Expectations Test. It's actually pretty straightforward. It just asks, does this product meet the baseline safety expectations of the average ordinary person buying or using it? For a lot of everyday items, this is a super easy standard for a jury to apply, just using plain old common sense. Which brings us to Section 4, the Risk Utility Act. Okay, but what happens when a design is highly technical?
Sometimes ordinary consumer expectations just aren't enough to judge complex safety engineering. So, the Barker Court created a second test, the risk/utility standard. Under this rule, a product is defective if the risks inherent in the design simply outweigh its benefits. And here's the kicker. If a plaintiff can show the design caused their injury, the burden of proof actually shifts over to the manufacturer. Suddenly, the company has to prove to the jury that the trade-offs in their specific design were mathematically and practically justified. So, how exactly does a jury weigh those scales? They look at some very specific balancing factors. They ask, what was the magnitude and probability of the risk? Was there a mechanically feasible alternative design they could have used? How much more would that safer design have cost to make? And if we force them to add this safety feature, does it totally ruin the usefulness of the product? We see this play out powerfully in a massive tobacco case, Evans versus Lorillard. Marie Evans tragically died of lung cancer after smoking Newport cigarettes for decades. The plaintiff successfully used the risk-utility test here. They didn't just stand up and say, cigarettes are dangerous. No, they proved the manufacturer could have feasibly designed a safer alternative. Experts testified that the tech existed to make a cigarette with non-addictive nicotine levels and safer tar, all at a reasonable cost. Because the company ignored a safer, feasible alternative design, the product was deemed legally defective. On to Section 5, failing to warn. Now we hit our third pillar. This deals with perfectly manufactured and perfectly designed products that just lack the instructions needed to keep you safe. But before we dive into a failure to warn, we have to ask a logical question. What if the danger is just open and obvious? The law is pretty practical about this. A manufacturer doesn't have to warn you about things that are common knowledge. You don't need a warning label on a kitchen knife telling you it's sharp, right? But that brings us to a devastating case about risks that are incredibly hidden. In McConnell v. Costco, a babysitter left an 11-month-old named Matthew alone in a high chair. The child tried to slide out, but his neck got caught on the high chair's tray, cutting off his oxygen, which resulted in permanent, severe brain damage. Now, the manufacturer tried to argue that the danger of leaving a child unattended in a high chair is open and obvious, but the court flat out disagreed. While falling from a high chair might be obvious, the visceral, hidden risk of a child physically strangling on the tray itself was absolutely not common knowledge, so a specific warning was required by law. So if a warning is required, was the one they provided actually adequate? When you break down the actual warnings on that high chair, you see why they were legally defective. First, look at the placement. The chair was sold without a manual, and the physical stickers were slapped on the back of the chair and underneath the tray, literally places a user naturally wouldn't even look. Second, the content itself was weak. The labels just gave a basic instruction like, never leave baby unattended. They completely failed to warn of the actual severity of the hazard, which was death or strangulation. Because of that obscure placement and weak content, the warning was effectively useless. Finally, Section 6, protecting the consumer. Let's pull the whole shebang together. Why did the justice system engineer this entire strict liability framework in the first place? Well, it all comes down to policy goals. In our modern, highly industrialized society, everyday consumers are totally outmatched by mass production. Ultimately, the courts decided that the burden of loss caused by a defective product should be borne by the manufacturer who created it and profits from it. They're the ones in the best position to buy insurance, distribute the costs, and most importantly, actually improve the safety of the designs. The goal is to provide maximum protection to you, the consumer. As we wrap up this explainer, I want to leave you with this thought. Look at the products around you right now. Who truly bears the risk of our modern industrial age? The next time you take a product off a store shelf, sit down in an office chair, or get behind the wheel of a car, think about this invisible legal framework we just explored. It's this delicate, high-stakes balance between corporate innovation and your personal safety, and it's operating in the background every single day. Thanks for joining me to figure it all out and keep questioning the world around you.